We good? Good afternoon. Welcome to the January meeting of the Rehoboth Beach Board of Adjustment. Let's start with a roll call. To my left,
William Pearlstein.
John Conacy.
Barry Brandt.
Fred Townsend, Town Solicitor.
Edith,
Sorry, attorney for the board, excuse me.
Edith Heron.
Mark Saunders.
Thank you. Everyone's here. Thank you. As far as public notices, Ann, was the meeting and public notice properly posted, and did we receive any correspondence with our case today?
We have received one piece of correspondence from the Pam Baker of the Rehoboth Beach Homeowners Association on January 12th for the 1 Rehoboth Avenue case.
Okay.
The agenda was posted and published in City Hall and on the portal on January 13th, 2023. It was amended on the 18th and reposted the same day. The public notice was for 1 Rehoboth Avenue, was posted December 29th, 2022. I can verify that it was sent to newspapers in a timely fashion. I do not have that paperwork with me.
Okay, thank you. As far as approval of minutes, there are no minutes to approve, and there is one or was one notice of prior decisions. We've all seen it and signed it. Are there any other final questions on that? That was for the case on Virginia Avenue. Old business. This afternoon, we have one case on the calendar, but before we get to that case,
Oh, do you want to do the secretary?
that's where I'm heading to.
Okay, I'm sorry.
I'm saying before. We spilled the beans. We need to appoint a secretary. Do I have any nominations for secretary, basically to oversee the clerical work of the Board of Adjustment?
Anyone willing to serve in that role?
I would be willing to serve in that role if I understand clearly what the responsibilities are. I've asked a couple of times, and I know we've had other things we've had having to be dealt with, but I'd like to understand, and I might certainly be willing to take those responsibilities.
So the responsibilities that exist are referenced in the rules of procedure that we're going to be talking about during the course of the meeting later on. There aren't many references to the secretary's role to the board, but there may be a couple in here. I think you would be the primary liaison to staff, but that would be in office. If staff were being pulled in different directions by different members of the board, I think staff could say, well, I'm going to take my direction from the secretary as opposed to others. I can't imagine a scenario like that happening, but in theory.
When you say staff, are you meaning staff from the city staff? Okay.
Yes.
Do you mean like Ann, or?
So the minutes get prepared, for instance. Technically speaking, they're the responsibility of the secretary, but the secretary is not expected to prepare the minutes unless we want to have that discussion. I don't think that's been the practice of this board for quite a while. I think the city secretary prepares the minutes or has them prepared. And the liaison to the board would typically probably be the chairperson or chair of the board, but the rules are such that it might be the secretary. And the secretary might step into the role of the chair in the chair's absence, for instance.
So would it be more of an overview or a review of the minutes, a pre-review of the minutes to be sure of their accuracy before they're brought to the board, just to have another set of eyes on them? I don't understand exactly.
Yeah, I wouldn't think so.
Or is it too murky?
I would think that the minutes would get circulated, and the secretary may want to play a larger role or take on more of a responsibility to review them prior to the meeting, but not any further in advance of the meeting. The minutes are going to get prepared when they get prepared, and there's going to be a limited window for reviewing them. I think the secretary would take on a sort of an enhanced set of responsibilities for reviewing them.
Well, would I be if I took the position, would I be overstepping Ann's role or stepping on your toes in any way, Ann, or That's what I'm hearing. That's what I'm thinking. That's
No.
what I'm thinking.
No, that's not what I'm envisioning at all.
Ann would be happy to have you take over the minutes.
Anne is being, things are demanded of Anne from all over the city. So we're not adding a new layer.
Yeah.
We're not going to add a new layer of supervisors for Anne. Anne's going to prepare the minutes, and then I would say the secretary should take just special care in reviewing them, as opposed to the extent to which you might review them if you were not the secretary.
I see. I would feel uncomfortable being, if it were, you've said it isn't, but I just want to state, I would be uncomfortable feeling like I needed to take detailed minutes during one of our meetings. I felt that my focus would be
Lose focus.
distracted
Right.
from the issues at hand, which is not what I'm supposed to be doing.
Right.
So I'm sure we could work it out, Ann, perhaps, but
Well, I don't think Anne would need to change her
good.
practices
That
at
would
all.
be great.
And in the rules, it's a very general statement, the statement of it, what the secretary does, so.
And, you know, I don't know, you were on the Board of Adjustment longer than I, but I don't know that Walt ever
No,
had any, there was never, there was a title, but it wasn't a responsibility.
that is correct.
Does that make sense?
The other aspect of it that I saw somewhere was that the secretary is responsible for the decision or recording the decisions, but
That's Fred.
Is that the city secretary that, or the secretary to the board?
and maybe I misread. I'm just saying it seemed, the whole thing seemed a little bit murky to me. But you do such a great job, like preparing the decision, and it seemed like you need a legal background in order to do that, to make it precise and explicit, so that would be, that wouldn't be appropriate again.
I don't think the secretary would have any extra responsibility with regard to the preparation of the notices of decision either, but if the secretary wanted to review them more carefully and to communicate with council about edits and clarifications and whatnot, then the secretary should feel, welcome to do that.
So what I'm hearing, I think, is just an extra set of eyes and ears on the board, the business of the board, to be sure that we are meeting, that there's nothing on our end that we're not meeting appropriately. Is that what I'm hearing correctly?
I think that's fair.
Is that-
Yeah, I mean, it just says, they shall perform the duty as requested by the board and shall supervise the detailed work of the board.
Generic.
That's pretty generic.
Yeah.
Very.
Yeah.
So I can't envision an example, but a secretary might be called upon to sign something that
Oh.
evidences
I see.
an action taken by the board.
I see.
But we do issue our opinions. Those are signed right now, but we're changing our practice with that regard, because we're going to, or in that regard, because we're going to vote on the issuances of our decisions in the future. That's one of the proposals in the modifications to our rules, is that we will vote them out so we don't have to sign them out.
Oh, I see.
And I think that will make us a little bit more efficient in that regard.
That speeds the process along then of getting the decision out to the public or the applicant or.
Right.
Okay.
Right. I don't think it should be necessary for everyone to sign. And what happens when a person who participated in the decision wasn't at the subsequent meeting where we're trying to issue the decision? Do they need to sign it? Now, if a majority voted out, then it's out and published.
Well, based on that discussion, I would be willing to take the position if so asked by the board.
I nominate Edie Herron to serve as secretary.
I'll second that. All in favor?
Aye.
Aye.
Do I vote?
Thank you. You got outvoted, Edie.
On the first ballot, too.
Yeah, conflict of interest.
You could vote yes or no. You're still the secretary.
All right, moving on to old business. May I ask, we had case 0922-09 for 229 Hickman Street. We had an action, or the board requested an action for the applicant and the city to get together. Did that ever occur, or is it coming back, that case?
On 80 Oak?
No.
sorry.
229 Hickman. They wanted to raise the
Last
height of the
meeting.
building?
It was the last meeting.
Yeah, we did meet with the applicant,
Okay.
and I don't know what the status is since that meeting, but we did meet with them and
Okay,
and
so
have a plan.
the action was completed then. All right, thank you. And there's, I guess I don't have, they may come back, they may not, we just don't know. Okay, thank you.
In general, are we given, excuse me if I may ask a question, are we given an update, or do we need to ask specifically for an update like we did in this case, like Barry did?
In general, you wouldn't.
Wouldn't know?
You wouldn't hear, I mean, our duty here is to evaluate applications for variances.
Right.
And very often, and one of the things we're trying to avoid, particularly in these complex cases, is where an applicant and the city aren't on exactly the same page. The city's interpretation of the code might be different, and might be, and usually more appropriate and accurate than maybe an applicant's might be. And then once the information is exchanged, then what happens? Well, we find that there's no need for the application to go forward. I'm guessing, I haven't talked to anyone, but I'm guessing that something like that may have occurred in the other case. But generally, there's no follow-up between the board members and
That was really
and
my
staff.
question. Thank you.
Okay. Okay, several days ago, for our case, 1 Rehoboth Avenue, several days ago, the applicant reached out to our solicitor or our counsel to indicate a desire to delay today's public hearing and the presentation of their application. Before we would accept a motion for a continuance, I want to ask any general questions or preliminary matters that need to be resolved today before we make such a motion?
Not from me,
Okay,
no, sir.
okay.
I can make a remark too. I'm not regarding
Okay.
preliminary matters, but about this particular request.
Okay, do you want to do that now, or?
Sure.
Okay.
So it is, again, not uncommon for a request like this to be made, particularly on a very complex case. And we had fielded some questions here that were circulated between the city and the applicant that were generated from within the board and maybe from outside the board regarding the impact of whatever flood districts are applying to the project and the underground parking component of the project. And it became apparent that there was a need and desire to exchange information between the applicant and the city to make sure that the parties were on the same page as to what impact the flood mapping might have. Some of us have been in meetings before where applicants and the city have been unable to agree on, say, the proper calculation of gross floor area and whatnot, and that puts the board at a huge disadvantage and renders and puts us in a situation where we might feel like it's not appropriate for us to go forward if we can't get an agreement on the basic understanding of the applicable facts. I think that's what this was about, just to allow for some time for the parties to meet and come to a consensus on that point, so it didn't potentially have the effect of being a distraction to us when we hear the application come forward. It is not anticipated that the applicant wishes to withdraw their application in any way. They want to go forward, but they want to do it in a way that is, I think, most efficient. I think the city would agree that that was an appropriate thing, and I think the members do as well. So that's what, I think that's what prompted this request. And again, we've seen these many times. This board has heard them many times, and in the absence of some kind of belief that the applicant is dragging their feet for some reason, these motions are generally granted without a lot of analysis.
Can I ask a question?
Mm-hmm.
Obviously, they won't pay the fee again if you defer it, correct? I'm sorry, they will not pay the fee again if one defers it. How do you handle the advertising? Does it just gets advertised again when it finally gets up, or how does that work? I don't know, I've never.
So FOIA requires us to publish notices
Okay.
of our agenda and to advise the public that a
Okay.
public hearing is to be scheduled. And in a case like this, if we, and I anticipate that we will, move this to a date certain, then anyone who was interested in participating today in the public hearing would know that the public hearing on this is going to take place in April, I believe. That's the request.
Well, it'll be on the agenda, and the agendas all get pushed out and posted, so I don't think there's going to,
Well, it's
That's right.
advertised and the neighbors are notified, and that would probably have to be done again.
And re-signage
Yes, you
probably.
do it, the re-signage, everything has to be done again.
And not the mailings or anything. The signage should stay up, I believe.
Gets, if I may, it just gets corrected with the new date.
Okay, it gets modified and corrected. Does that answer your question?
Yes.
I have a question, and maybe you can't answer it. Was there any other reason besides the FEMA floodplains for which the applicant felt he or she, or that group, excuse me, needed more time? Or was that was the issue that caused the change?
No, I think that's the issue.
Okay.
I think we could have gone forward were it not for a desire to make sure that this group wasn't in a position to be distracted by facts which may or may not have had any significant impact on the project.
Thank you.
Okay, with that, we can accept the motion for a continuance of the case for 1 Rehoboth Avenue.
Is it a continuance or a deferment?
Well, yeah, whatever we call it, we do need to incorporate into the motion that the, and this is important for legal reasons that Mr. Mandalis has shared with us in the past, that we assign a date certain to the, to this public hearing. So again, anyone who is following this will know when the hearing is likely to occur so they can make plans to participate. And the request that's come in is that we handle this in our April meeting, and that is probably has a lot more to do with what we know about our attendance over the course of the next 2 months than it does have to do with the length of time necessary to exchange information between the city and the applicant.
What is the date?
April 24th is the,
24th.
Oh,
April
okay,
24th.
thank you.
Yeah, and I do agree. I think deferment's better than continuance because we did
We
not
didn't
start
start.
the case.
Okay.
Okay.
All right, I move that we defer case number 0822-10 to a day certain of April 24th.
And day certain is a specific term, is that correct? Is
Yes.
it a legal term?
Yes.
I didn't know, I'm just asking.
No, it's not.
I
don't
ask
think
every
it's a-
question I have.
It's not meant to be a legal term.
Okay.
Thank you. I'll second that. All in favor? Aye.
Aye.
Okay,
All right, so we're continued. Very
we
good.
are continued.
Or deferred.
We are deferred, right? And
So if anyone
so-
is here, if anyone's here on that issue, it's not going to be taken up today, and it will be taken up in April.
in April. And thank you for attending today. And we have one piece of new business that we wanted to get to, the rules of procedure. And I guess, did everyone get a chance to review them? I know we had some minor changes, I believe. I don't know.
I had quite a few things.
You did? Okay.
I've edited many things, and so I guess I have an eye that finds things to people's happiness and sometimes their discontent. So, and I just had given that to Fred now. I don't know, are we going to go over nit by nit, or were you planning to redo a draft and rework?
I don't think it would take that long for
Okay.
us just to go ahead and go over these.
Sure.
I haven't seen Edie's changes, so,
Me
yeah.
neither. So we can talk about them
can
as
talk
they
through it.
come up.
And are there options to talk about additional than what's here?
There always are.
Okay.
So if during the course of this discussion, you want to suggest that we either consider something today or consider something in the future, then that's totally appropriate, given our agenda.
Okay, and when,
I think these,
they're at the end?
these rules, I think as we go through them,
Okay.
would be best, and that if,
Page by page, perhaps?
yep, there aren't that many.
No.
There aren't that many.
oh, did you bring them?
And that I don't think this is our only bite at the apple. So if we wanted to make some changes today in the rules and adopt them and consider some other changes at a later date, we could bring this back to our agenda and deal with it when we're ready. So as you can see, if I can just dive right in, there is a desire to be gender neutral when we're referring to the chairperson.
And the next one after says chairman still, the one that begins presiding officer, did not take out the man,
Gotcha.
was still chair.
All right, so I am not familiar with, I don't know if there's a rule that says chair is an appropriate specific or appropriate office, or whether it should be chairperson, but chair is fine with me.
It's fine with me.
Jay Powell is the chair of the Federal Reserve Board.
Okay, all right. Well, that's all we need.
Good enough for us.
Yeah,
Exactly, okay.
okay, so that's a winning argument right there. So we're going to go with chair then, wherever we see the term
Right, I
chairman.
had found a few others later.
There
But
are
also
some.
on this page, the one that begins public business,
Mm-hmm.
you have mater rather than matter.
Yeah,
Means any matter over which, those were the only two things I found on this page, the chairman and matter.
okay.
Did anyone else find anything?
Oh, in general, I mean, I found city secretary was repeated twice.
Yeah,
Yeah.
it's some,
Yeah, there's little things like that.
yeah,
Was
on
that- is
page
that on
one.
the first
No,
page?
it's not on page one.
Okay, so,
Did you, there's a tiny, on Board of Adjustment, I think it's, isn't Board of Adjustment or board?
pardon me?
Which line?
Third item in definitions.
Oh, yeah, it's,
You said Board of Adjustment of board. I think you mean Board of
or,
Adjustment.
I think you mean or, yeah.
Board of Adjustment of the City of Rehoboth Beach.
No, it's right up
Oh,
here.
gotcha,
there,
right, Board
that
of
one.
Adjustment. Yeah, that of should be,
Or,
or,
that's a problem with spell check.
Mm-hmm.
If it's a word, it gets in there.
you're right, yeah.
Right.
And I'm certainly not above my share of typographical errors. These rules are the rules as they were adopted probably
You,
10 years ago.
when you and I met, you gave me something, this was when we were, before, my term began, you gave me something from 2019, which this is not exactly the same thing. Maybe that was just the version that was there at the time, just for me to look at.
Okay.
So I don't have a better number for the date or anything.
So these rules can be adopted from time to time, even if they're not changed. And sometimes if we have a big hearing coming up, it might be advisable for us to adopt the rules again,
And have them.
just to make it really clear that these are the rules that these applicants have to abide by.
That would be, that raises a question. If we did that, and someone says, I want to make a change, the case that you're, if you try to do it right before a case, wouldn't the applicant say, yeah, well, you can change them after my meeting? If, I would think.
Yeah.
They would have that right.
So, it's going to depend on whether the change is making a material, or having a material impact on the applicant, right? So like the use of the term chairman versus chair would not have any effect on it.
Okay.
Yeah.
Fred, there's some things all the way through this that are in very light type. Is that just,
That's words, track changes.
So what happened there is,
okay.
yeah.
Do you use
so-
track changes?
I don't use Word.
well.
I have a Mac, I use Pages.
I see.
So what it's showing is that when you see the faint lettering, that would appear in red. That would appear in,
If I had a color printer. Okay, all right.
so I believe Ann's suggestion was, this may have come from Ann or from the mayor, that we officially include on all our agendas, but after the call to order and roll call, a verification of meeting and public notice, which is something that you just heard the chair and Ms. Womack go through. I think was been typical
Yeah.
for prior chairpersons to ask for a verification. So why not just put it on our agendas?
What about, the approval of decisions, now that you're gonna start to do that?
Right, so there's a suggestion that it be placed after the item approval of minutes. So what's been circulated is the proposed insertion of language to the effect that the approval of notices of decisions would also be on every agenda. And there might be instances, and probably would be instances, where we don't have a decision to approve, but if we leave it on the agenda, we're less likely to forget about it.
Right.
Okay?
Page 2.
Old business, new business. Now, old and new business is something of an antiquated, hi, are you here for the public hearing on, yeah, so that has been deferred. The public hearing is not taking place today. It's going to be heard in April. And you can follow the website for that, but if you can remember what's the date, the 24th? 24th of April, that's when this is going to occur. You're welcome. So old and new business is something, it's not really recognized in FOIA that you have old and new business. I mean, we have a legal obligation to notice what it is we're proposing to do as an action item. I don't think it matters whether it's old or new business, but if the city's more comfortable maintaining old and new business as a,
I think the reason why that's on there is that there is a case that would go from 1 month to the next. In the next month, it would show up under old business.
okay, that's fine.
And you would typically do that before the new business? Yeah, okay. I'm okay with that.
Okay, that's fine. So our agenda is going to have to, we can't just do anything that's old business because we have posted on our agenda that we're going to consider old business, because the public doesn't know what that is necessarily. So we still have to go through the, we have to at least minimally describe what it is we might be considering at an upcoming meeting.
Same thing with other business.
Same thing with other business. It's not a legal, not a legally recognized term, but it's fine for our use. Okay.
So in 1.4, you have an incomplete sentence at the end of it. It says, which the remainder of the, and I think you might mean presentation will be heard,
Oh, my.
those words, correct?
Motion to suspend a presentation should include the date and time at which the remainder.
Of the, it should say presentation will be heard or some such.
We certainly have the right person as secretary to this board, I'll tell you that.
When I've done other things, my friends have always called me, or my co-people have always called me Eagle Eye. I don't know if that's good or bad, but I'll be happy to use those eagle eyes
Is that
on
what
the
they, that's
behalf-
what they call you when you're present?
That's right. Gosh knows what they call me when, behind my back.
So, yeah, I think you're right. I think that should be presentation should include the date and time at which the remainder of the presentation shall.
Or shall, perhaps, then will.
Remainder of the presentation, what? Shall occur, or words to that
Whatever
effect?
you
Shall
like.
be heard.
Shall be heard. Okay, that sounds better. We good with that?
Fred, can we go back on 1.1? You said approval of notices of prior decisions. Is that what this is? The decisions are called notices of prior decision?
Yes.
Okay.
So the decisions can be labeled and are appropriately labeled as notices of decisions when they're in writing. And I understand where you're coming from with the question that instead of just saying decision or judgment, notices of decision
Okay,
is, I think it wouldn't do any harm if we were just to say, approval of decisions. But I think the practice is certainly in some other jurisdictions to refer to them as notices of decision. And that's in part in recognition of the fact that we've made a decision. Now we have to issue a writing, which is required in order to trigger the appeal period. So there is a little bit of a discrepancy between the term decision as it was made during the hearing and the issuance of the writing. Yep.
okay.
In 1.6, I didn't find anything missing or incorrect, but I do have a couple of
But
questions.
wait a minute, we're still on 1.5.
Oh, excuse me.
Yeah.
Okay.
So
Was shall not in there before?
Right.
It wasn't. I guess it wasn't.
No,
I
you
mean,
deleted may and added shall.
You're not picking up.
Oh, okay, I'm just seeing the light.
Yeah.
Oh, okay. Because you know what, the Planning Commission is changing their rules, and they're going to require an oath that, like we do. I just thought I'd throw that out there.
Just so you know, Jan, with track changes, anything that's been deleted has a line through it like may, and anything that's been added has a line underneath.
Okay,
so
no,
shall.
I've never been in a Board of Adjustment where they haven't done it, so that's why I was curious.
These hearings are, our business is appealable to the Superior Court. And in order for our testimony to be considered proper evidence, it's got to be under oath. Now, the Planning Commission decisions don't get appealed. I mean, I can understand the discrepancy. It's not like our business is more important than the Planning Commission's business, and they should require everybody else to testify under oath. That's unusual to me because usually the Planning Commission is charged with some responsibility to make recommendations to the commissioners as opposed to final decisions, although it does get murky.
Yeah, because their appeals are to the Board of Commissioners, but then the Board of Commissioners are appealed to the court, as, we know from cases.
So that change definitely needed to be made. And
So in 1.6, as I said, I didn't find anything that needed correcting, but I have a question. One of the things that we've reiterated a bit is the board members may ask questions at any time throughout anyone's, I'll say, testimony or any wording. Do we need to state this, or is that just a given that we know and we don't have to include it in 1.6 or anywhere else?
I don't think that
Okay.
it needs to be stated. I
Okay.
don't think it would do any harm. These are our rules. And let me think about this for a second. Like, if somebody, we're going to come up on a rule as to when we want our meetings to start. The public are not going to go to our rules to find out when meetings occur.
Right.
They're going to go to the website. They wouldn't know where to find our rules or wouldn't find them terribly helpful. These are our rules, they're not laws, they're not ordinances. So I would say it's not a omission that we don't specifically say.
And we are,
We could say it in Rule 8, where we talk about when a member desires to speak. Maybe if the member can speak any time, maybe it needs.
I believe also when we close the public hearing, we as the board, we are allowed to continue to ask questions, even though the public cannot speak, and then we may have to stop the city or the applicant from going into different facts. But I believe we can ask questions during the presentation, and then when we close the public, I think we're allowed to.
I think if you wanted to add it, Fred, I'd do it in 1.2,
1.2?
because that sort of just
Okay.
follows on Barry's point, because it says when the public can talk, and then if you wanted to add something that, any member of the board may,
Oh, okay, another sentence then?
Yeah.
Okay.
So I think
ahead.
that's a really good suggestion, because as I was looking at 1.6, it's, these A through E are procedures.
Yeah.
And this is a reference to the order of procedure, not to whether the members are authorized to ask questions. So I don't think it should go in
I mean,
1.6.
it would really follow from 1.2. The
1.2.
order of business, the privilege of the floor, and then
Okay.
it's something along the lines of, any member may raise,
Okay.
A question or a
any
comment?
time?
Yeah, because that was a misconception that I had, and in my first meeting with Fred, he was able to, as with many things, clarify, because I thought that the Board of Adjustment went more as if it were a trial basis, where you could only ask, we could only ask things at certain times, and he said, no, you folks can ask anything you want at any time. And I thought, oh, well, that's great to know for me, but I didn't know if we should make it a wider statement. That was where the question came from.
Okay, good suggestion.
And then in 1.6C, do we really mean that we're going to read the correspondence or we're going to note it?
My personal viewpoint is that we never obligate ourselves to read correspondence. First of all, you don't know what
Yeah, exactly.
horrific thing could be you could receive in writing that you'd be asking maybe Ann to read, which and
Or it could be 12.
pardon me.
Yeah.
Well,
Or it could be 12 pages long, too.
it could be 12 pages long. So
There could be 75 letters.
Yeah, so why don't we say correspondence noted,
I like that.
noted for the
Good
record?
point, very good point.
I like that. I don't think we wanted, also a public policy behind making that change is I don't think we want to encourage people to submit things in writing in advance of a hearing, as opposed to being here to hear the presentation, to see whether their questions are being answered by the presentation, and then maybe to ask a better informed question, or make not a question, but make a better informed comment if they're here.
Well,
Because-
I have to disagree with you on that, because so many people in Rehoboth don't live in town. And many people are gone, people that probably we all know are gone to Florida or someplace for several months. And the only way they have to communicate is by writing.
So I get that, and I'm not saying we should disallow written submissions. You don't disagree that noting the receipt of the correspondence is sufficient?
I think it's totally sufficient.
Okay, good. So I think.
Totally sufficient.
Yeah, okay. Right. So I understand that, and that we live in a resort town which has a different set of phenomena that we need to be mindful of. Sometimes people aren't here in the colder months. A lot of people are working in the DC and Northern Virginia and other such places and find it impossible to be here. I just want to reiterate that sometimes a written submission is made, that has to be made if it's to be included in the record before the hearing, and that unfortunately is before the evidence is in, or before you have a chance to consider what's being said. So it is not the ideal way to persuade the board, but it might be the only available method for someone who can't be here. Right, yep.
2.1 is just a spacing hanging indent issue. The hanging indent hasn't been,
So I did find, using the track changes, that the formatting got fouled up, and I couldn't fix it.
Sometimes Word does that.
Yeah, and it's very frustrating. So I think when I adopt these changes and add the new ones that we're making today, I will be able to fix the.
you probably have a hard return after other, and the hanging indent was changed before it.
Yep,
So, in any way.
that's exactly
I
what
never
happened.
heard that term, hanging indent, but I know what you mean.
Really, no, I've taught Word, and
Yeah, Word Perfect, I think, it was easier to go in and find.
you could go behind the scenes. Well, there's still, if you use from the if you use this tool on the home.
Paragraph.
Yeah, the paragraph tool lets you see what's been done. Shows you the spaces, the hard returns, and everything, and they never print. But that's a tool on the home ribbon.
All right.
I'm sitting here left wondering if anyone watched CBS Sunday Morning yesterday about the AI. They said lawyers will love this new AI that can write documents. Fred would just have to say, please write the rules of procedure for the Rehoboth Beach Board of Adjustment, and zip, it would come out.
It raises interesting questions,
Yes,
though,
it does.
for students.
For
And
students.
yes, and writing papers.
Absolutely.
Well, and I guess, I gather, since Fred wrote this, that they don't have secretaries anymore. I just told Bill I was thrilled that I had a secretary throughout my entire career. But I know that in the bank, even after I left, I mean, executives, 5 or 6 of them would share one secretary.
Yeah.
You know, at Bank of America, you did. I mean, I guess maybe Ken Lewis got his own, or
Well,
whoever's
some,
head now.
some of us,
Brian Monahan, right? That was before I left.
some of the older practitioners in the firm are still using a dictaphone, but I mean,
Oh, my gosh.
dictaphones are hard to come by. I mean, yep, most of these kids entering into the field now are doing their word processing. All right, so 2.2, regular meetings shall so I did want to add this language. Again, this is our rule, and I don't think we want to make a habit of restricting ourselves too much. This is not where the public is going to go to find out when their meeting is to occur. So we just added some language saying, unless otherwise determined by the board, the regular meeting shall convene at 2:30, which gives you flexibility and yet also gives you reason to expect what time those meetings were going to occur. And that we're limited in terms of when Ann can be available because she is serving all of these different committees and boards that meet in addition to whatever other responsibilities she has. This room is occupied at different times. And anytime we want to change the time or consider when we want to meet, we've got to clear it to make sure our space is available.
And she has 2 boards on these Mondays because Parks and Shade Tree meets on the 4th Monday in the morning, right? So she's got 2 boards in one day anyway, plus everything else you do.
So at different times, we've talked about whether 2:30 is the right time to start. I think, Jan, you've got some issues on the 4th Monday.
I do. I have another board meeting that I get paid
Right.
to attend.
Yep.
That ends about 12:30, 1 o'clock.
So we don't need to have a extensive discussion about 2:30 right now.
2:30 is fine.
Yeah, okay, good. I think we had that discussion with this particular group already. All right. Okay, so
3.2, you have another incomplete sentence there at the end because you've added applicant receives a certified mailing by general mail.
I think that's a comment.
Excuse me.
And you don't see that. I think that this is a comment that maybe came out of your office. So the rule we're talking about is a public notice. It says, public notice, property posting, and advertising of meetings and hearings shall comply with applicable provisions of state law and city ordinances. In addition, a notice of hearing shall be mailed to an applicant or appellant or an attorney for either at least 15 days before the date of the hearing. That's the rule. And then there's a comment, and I think this may have come from Ann, saying appellant or applicant receives a certified mailing by general mail.
They receive certified and general mail.
So,
So it goes out in general mail, and then I also send out a certified one
so
to the
that,
applicants,
I'm sorry.
to the applicants only.
So that's your practice. I don't know that we need to amend our rule to indicate what the practice is.
But you've listed other practices here. The property posting is a practice, right?
Well, one is
Well, that's
question as to
required
whether
by
it's
FOIA.
Oh,
whether it's
okay.
required
Oh,
or whether
okay.
it's in addition.
Yeah, FOIA requires a public notice.
Okay. But the property posting, I mean, isn't that a practice rather than a,
No,
No,
Oh, that's
no,
part
no.
of it.
That's law.
that's law, yeah.
Okay, the posting as well, which means this, you're talking about the signage there, and, okay,
The law.
Thank
A-
you.
And there's no law that says that the signage has to remain in place for the duration or anything, which is, there's just no real way to regulate that, because if the sign just,
Well, one of the problems I would have is if we would even try to do that, especially with this one that's gonna be coming up in April, to leave the signage up from now till April, it's never gonna stay there.
and you can never be sure that, well, you can't, it's not fair to blame the applicant if the signage disappears.
We had that come up last.
Well, not from the boardwalk. I mean, that would be insane. I mean,
Right.
the wind could blow it away, you know,
That
momentarily.
came up earlier, last year. We had a case about, I think, on Sixth Street, that there was some issue about someone took the sign down, and it may happen, you know?
So I think this is more of just a comment that came from Ann about the rules, saying, and by the way, the applicant, in addition to the public at large, the applicant gets certified and regular mail notice of the date of a hearing.
Fred, can I ask you a question?
Sure,
Is the
sure.
200 foot, is that law or is that just our practice?
Law,
It is law.
that's law.
Thank you.
That's, those properties or parcels within 200-foot radius of the boundaries of the subject parcel are required to receive, is it certified mail? Yep.
Actually, I believe it is in the municipal code about certified mail.
So,
I have to follow the code.
right. So this obligation is not generated by our rules. It's generated by both city ordinance and I think state law. But Ann has confirmed definitely that it's in the city's ordinances. Any question about that?
Signage is also in the ordinances too.
It's only interesting because the 200 feet here in Rehoboth is 4 houses away, whereas, go out a couple miles and it's 1 house away.
Right,
It's
right.
But it's like, it's more, like in Kent County, it's more than 200 feet.
Right, oh, I see. Well, Fred just said it was law, though. The 200 feet is law. So maybe that's minimum law. Maybe it's minimum
Yeah, I
of
mean,
200
I
feet.
only know about I only knew about Kent County when I saw
So-
something go up.
So I didn't anticipate this question. I think there's a state law reference to these mailings of notices to.
I'm sorry, I didn't mean to go off the track.
No,
even.
no, it's good. That's one of the, I think it's helpful for us to think about what everybody is doing.
As a resident, we've heard complaints in my former job on a homeowner association. We heard complaints that people that were 5 houses away or 6 houses didn't know about it. And I was
Right.
just wondering how that 200 feet came about.
So there have been challenges. There's at least one case that I remember reading years ago about someone saying, I didn't get the notice. And I should have gotten a notice because court rules or the city ordinance says, and this might not have been Rehoboth, that I should have gotten one because I'm in such close proximity. And the courts just looked to whether or not there was an attempt to satisfy the practice, and if,
Let's run that scenario down then. If we get a resident coming in and say, I did not receive the notice, do we have a case of deferral, or do we ask them?
No.
I mean,
Well, Barry, the problem is they don't know about it till after the fact. usually.
Right.
After the
They
fact
say-
that it
After they read
happens.
the results, and then they go, why are they building that hotel? Nobody
or-
told me they were building
yeah.
that hotel.
But even if they hear it from their neighbors and they come in here just angry, do we give them, or do we move forward?
The courts have said that that is not a defect that rises
Okay.
to the level of upsetting a decision or anything.
Okay.
One of the things with the city is there are going to be people in this town that think that should be getting a notice, and we're mailing it to the property address that we have on file.
Correct.
If they've not changed it, and say it goes to Bel Air in Maryland, and they're saying, no, we don't live there anymore.
Yeah, we moved.
It goes to Bel Air. It's their responsibility to notify us.
In a condominium situation, does it go to each individual condominium owner or just to the association?
It goes to
to
the
know.
association and each individual owner.
Oh, my
Oh,
gosh.
both, okay.
That must be a lot of mail in the Henlopen, or one Virginia.
Bill, did you have a comment? No. Okay.
I think this is wonderful, that we have the latitude to be able to do this. Don't you, do you folks agree?
You mean the afternoon off, so to speak?
Yeah, it's like a snow day from school,
snow
and,
day.
and we can use it in such a productive way.
While we're sitting here having a conversation, it brings up a question. We heard on the news recently, TV, that the commissioners are planning a change in parking for hotels. The point of when they make a zoning change, is it the moment it's put into the online archives? Is it the moment we get the paper
I can
printout?
answer that.
You know, sometimes you wonder, when do we act on the new?
Actually, Max, what's his last name? Max Walton.
Walton.
Actually made a point at a meeting of planners. And he said, as soon as it's introduced, it passed, even if there's an application already in, if it's passed, then that application is impacted. Because that planner that the Planning Commission has.
Even if we don't have it in print, right, because we all have physical hard copies
So
of
That's
zoning
what,
code.
that's what
Yeah,
Max
it's
said.
interesting.
So I don't know.
I remember several years back, Jen, there was a swimming pool incident where somebody had submitted plans for swimming pool,
Oh,
but
yes,
they
I
were not
remember that.
approved. And then in between, the regulations would change.
That's right.
So this is a little bit off topic.
Sorry. You got the juices flowing.
But there is this notion of something called a pending ordinance rule, which affects vested rights. Max Walton, I would never question Max. He's the preeminent practitioner in this area. My understanding is for an ordinance to be effective from the date of its introduction, you have to hold a public hearing. And while the commissioners can't adopt the ordinance the day they introduce it, they can introduce it by a special resolution, have a public hearing, and hear a discussion as to whether or not they should consider adopting this ordinance. And if they go through those steps, then they can rely on something known as the pending ordinance rule. The pending ordinance rule would allow the drafter of the ordinance to make the effective date the date of its introduction, as opposed to what you typically see. Whenever there's an ordinance, there has to be an enactment clause. And the enactment of an ordinance is typically when a majority of the commissioners vote in favor of the ordinance, and sometimes it can be, the next fiscal year or something like that.
Anyway, when we get the updates, the paper, that could be a long time after. And I use that book a lot when I'm looking at these cases. So I don't know whether, I guess I'm just saying that there seems to be a timing issue in some cases.
Well, wasn't the court ruling in Baymart, didn't they uphold the fact that even after Baymart had been introduced, I call it Baymart, I forget what Keith Monagle called
They
it.
called it Beach Walk. is
Beach
what-
Walk, sorry, I call it Baymart, I've been here too long. And the court upheld that it was valid, even though that his project was introduced first, so.
Okay.
Yep.
Good point. All right, thanks.
Yeah,
Sorry
Mark, yeah, 'cause
sorry
Mark,
for
I
the
saw
diversion.
that.
It was not a matter of time, it's just a matter of, how far afield we should get from our agenda in this discussion. Because it's raining outside, and I don't know what we would be doing.
Well, I might be unpacking
having a snow day.
boxes. No, I started to walk, and then because it was not raining earlier.
Yeah,
And then I
it's-
had to go back and get a car.
I have something on 4.2, but maybe somebody has something previous to that.
Anyone?
In 4.2, there's a kind of a run-on sentence that there are 3 lines that begin with uppercase adjustment agenda by notifying. and the end is, the third line down says, "of notice or." Okay, that block of 3 lines, I suggest we replace with something like this.
This is 4.2?
This is 4.2.
Okay.
And most of it stays the same, but adjustment agenda by note of adjustment, because it's really Board of Adjustment agenda from the previous line.
Right.
By notifying the board in writing, and this is where the change comes, and
Should
then,
that be a comma in writing?
no, it should be period, writing, board in writing.
Oh, I mean, should there be a comma after the word board, or should that not be there?
I think you
Notifying
can,
the board in
you can use a comma or not.
Okay.
But what I suggest is, for sure, there should be a period after the word writing, then uppercase H for however. However, if any item requested, this is where I change things because it would be a run-on. However, if any item requested to be placed on the agenda is not, in the opinion of the board within its jurisdiction, or which does not meet requirements of notice or, and then you continue, or advertisement, it will not be placed on the agenda. So I have that in the copy I gave you,
Okay.
if you wish. But
Yep.
that was kind of unclear and a run-on.
Yep. So what we're talking about is this concept of members being able to place something on the agenda
Right.
for a discussion. One of the few authorities that a chairperson or chair of a committee has is to establish the agenda. And there can be, although in the case of Board of Adjustment, I think it would very seldom occur that there would be a desire on the part of a minority of the members to discuss something that the majority didn't want to hear. The minority, I guess, can force it onto the agenda so long as it's appropriate, given the.
But then it would not have been posted in the proper time. I mean, like on the Historical Society, we never bring anything onto the agenda that day. It's always consideration for the following, and I think that's appropriate. So at a board meeting, any member can say, at the next meeting, let's add this to the agenda. I think that's appropriate. But for me to, or Jan or Bill to say, hey, let's add this and talk about this today, no, I don't think so.
So Barry, that is what I meant, though.
Yeah, okay.
So the Freedom of Information Act would prohibit us from just taking up issues that aren't duly posted on
Okay,
our agendas.
good.
So I think we're saying the same thing. It would be an effort to get something, like if somebody made a request that, hey, we need to talk about these rules again, and they didn't end up on the agenda at a subsequent meeting, that someone could say, I would really like this item to be added to our next month's agenda, and that's fair. This would result in it being.
Well, I just think that needs to be clarified, so whether you use my wording or not, it's certainly,
No, I will refer to your wording. I'm sure it's acceptable. Yep, because this is not.
right,
Anything else?
not on that page.
Well, okay, so we've got underlined, in addition to conducting public hearings on applications, the board may invite public comment on matters of general interest to the board.
Which is an addition.
That's an addition. That's not objectionable to anyone, is it, right?
No.
No.
There. So what this is fleshing out is this notion of the public's right to participate, which started out as the right to observe, and then in the case of public hearings, it became the right to comment in the event of a public hearing. And then it's evolved to the right to make comments maybe at the beginning or at the end of a meeting during a public comment agenda item that's unrelated to the agenda. So if we've got something of general interest, somebody says at the end of a meeting that they want to make some remarks, we wouldn't rule them out of order. We would allow them to do it.
It's discretionary, though. It says may, and because
Right.
to the extent that it's something that's just beyond our scope, I think we need to be able to say that, that's just not something that this board can address.
Right. And oftentimes, that can happen.
Yeah.
People can start talking about building code enforcement and.
Right.
Yeah.
So that's why, as long as it's discretionary, I think it's fine.
So, and again, in concert with what you were just saying, Barry, that items can be removed from an agenda, but they can be deleted from an agenda by a majority vote, but you can't add items to the agenda. And the old rules indicated that you could add items on the day of. And that's not gonna pass
allowable,
muster.
yeah.
And 5.1 has a little bit, are you,
Go ahead.
you fixed chair, the city secretary and another board of adjustment member, and then it should just be period. Take out or wasn't deleted. You,
The city
It
secretary
says,
is
or the
twice.
city oh, that's the
see,
twice.
it's
Yep.
stricken, it's
Gotcha.
stricken. So it's just adjustment member, period, and delete the remainder, including the word or, but you'd already marked the rest for deletion.
Well, but there was underlined.
Oh, city
the
secretary,
city
yeah, but that
secretary.
was,
That's why it stayed in, but that doesn't
was
belong
doubled,
in there
right.
because it's a double reference.
Right,
Right, okay. What's next?
I found in 5.4, the city secretary is actually underlined.
That's because it's an insertion.
No, I mean, it was underlined. See, it's red and it seemed to me, maybe I didn't, it was,
So there's some inconsistency here. I think that some of these proposed additions were made using underline and strikeouts, and others were made using track changes.
right.
So this is an insertion.
Okay, but what I'm saying is, I believe, when I looked at it, it is underlined in two ways. One from track changes red, and one black that somebody physically underlined it, so
Okay,
you
but
can
it's
just
not
jump.
red, though. I'm looking at the official one, it's not
Right,
red.
okay. Well, then it was
So
underlined.
we're in agreement, it does not need to be
goes-
underlined.
right,
Yeah.
Yep, well, that'll be, when that's accepted, that underline will go away.
And then I saw in 6.2, this is a question, not a comment. I said, do we also need to list that we want to record each Board of Adjustment member's reasons along with the vote? That's been reiterated a couple of times, that we want to, when we vote, we say yay or nay and why. And I don't know if we record that information and if it should be listed in our rules. That's a
Well,
question.
It is critical that you give your justification for your votes, because there is always the prospect of an appeal, and the court's going to be looking to the record and specifically to what justification you offered to make sure that it's reasonable. If someone is arguing that east is west, and that's their reason, the court can, rely on that as for overturning the decision. So, and if you give nothing in the way of justification, then the court can't analyze or come to the determination that you've applied the correct rule if you don't give any reasons. So here, though, the rule is talking about written record made by the secretary of the board. When the decisions come out, it's important for me to incorporate the appropriate justifications, and of course I have to, I'm restricted by what is said and what's in the record.
Sure.
But I don't think we need to modify this Rule 6.2 with that in mind.
Okay.
Fred, question on that, and if I think you told me this, but I want to make sure. If Edie gives her 3 or 4 reasons and I happen to agree with them all, and I just say I agree with them all, that's sufficient?
Absolutely. Yep.
No, you told me that. I wasn't
Yep,
sure.
you
Thank
can.
you.
So we don't need anything about justification here, just the vote count.
Because they're all in the recorded minutes, and if it's appealed, then all those are transcribed.
Yeah.
But
not-
it is
not
part of the roll
Not the
call.
minutes, but the transcript you're talking about.
The
right.
transcript, I'm talking
Right.
about the transcript.
Right.
So that if this is appealed, then those recorded minutes get transcribed by a court reporter.
But justification, as I understand it, and I'm not adamant about this, I'm just trying to understand, is part of the roll call of the vote.
Yeah, but but what I think Fred is saying is that if it gets appealed, then that justification will be in the court reporter's notes. Anne doesn't need to put the justification that everybody makes into the minutes.
She may do
does,
that,
though.
she does that as part
does, yeah.
of,
But that's her choice.
but I don't think that she's required to do that. But, so this is Rule 6 regarding roll calls. A written record shall be made. Now, we vote on things that sometimes don't involve the interpretation of the code. We're going to vote on these rules. So I think if we add too much requirement here, we're going to end up possibly running afoul of the rules, because Ann might say that the vote was 4-1 on what time to meet in April, and I don't think we need to add a bunch of justification in the minutes for that.
It's only the cases that
Would
I
be the-
actually add the justification for the reason.
Yeah, so I would not do that. Yep. What's next?
7.1 looked fine with me.
Now, this is the one, Ann, where we're saying that a file shall include copies of meeting notices, date, time, and place they were posted, and the agendas, meeting minutes, and notices of decision. Yep, that was your suggestion, I think, or the suggestion of the city.
On 8.2, there's an omission of the word "the" as it begins. No member of the Board of Adjustment shall interrupt.
Right.
She said as she interrupted.
In 8.3, there's something missing in the last sentence.
Yes.
I don't know if it's a member's request, but something, the last sentence of it.
See, when a member's
It should be a
request, or is it
member.
when a member shall be called to order?
Member.
That member, maybe it's when a member,
It should be a member, not members.
yeah, when a
Called to
member.
order?
When
that
a
what-
member
That,
shall be
because you're
called
talking
to
about
order,
transgressions.
that member shall not proceed without the
Yeah,
permission.
when a member.
If you're speaking out of turn.
So just take off the S.
Okay. I don't know if it's been apostrophe S members' conduct or something. but-
I thought it was,
Oh, it could be possessive, so you'd make members possessive.
Or you could take out when members shall be called to order and just have no A. Oh,
But-
that member.
but-
No,
but-
it
but that-
refers
but
back
the
to a
clause-
singular. No,
but-
I see it. It
But the
refers
clause,
back
that
to the
member shall
singular.
not proceed refers back to it, so it,
I got that,
Yeah.
Edie.
I'm sorry.
That's okay.
yeah, I think it's a member.
Okay, so just go with,
When a member shall be called.
Okay.
Because you're calling, that's the errant member.
Correct.
all right?
And 9.1 at the second line has a "for" in the word members. It says member for RS.
Right.
The "for" comes out.
I don't know why that didn't get spell checked.
And then Rule 11, as it's labeled, I would suggest, since we're not using chairman anywhere, it would say vice chair and other presiding officer. And also in that one, an omission of a word, third to the last line of 11.1, shall be such an other member of the Board of Adjustment as is elected. It says shall be other member. Third to the last line.
Shall be such
I
other
see.
member
Such
of the
other
Board of
member is what I'm
Adjustment as
reading.
is.
Yeah,
That's what I'm
but
reading
shouldn't
too.
be such an other member? I don't know,
Other member.
Such as, and, yeah, how's the,
I think
No,
it's,
it should be
isn't it?
such
it
other
okay the way it
member.
is?
Other member.
Such other member, yeah, such
Okay,
other member.
okay,
okay.
that's fine. That's great.
So like whichever, I don't think is an appropriate.
No, I think it's fine the way it is.
I do too, yep.
Okay.
It's awkward, but I think it's fine. Anything else?
Not on that page.
What do we have, the 12.1?
The only thing I had there were the details of the secretary, and I think we handled that earlier. I don't know if we are changing or adding anything to the rules, but I think we decided that they were vague enough that we could live with it.
Yeah.
Okay, Fred, can I ask you a question on 14.2?
Okay.
All appeals and applications shall be accompanied by a survey by our licensed survey at the subject property, except when, is this new? Has this been in there all the time?
I think it's been in here all the time.
So the fact that we didn't have one, okay, thank you. On the last hearing, we did not have a survey, even though one was done.
But it says, except when this requirement is waived by the board or the building.
I know from
Yeah.
talking to the people that there was a survey done.
Oh,
Yeah. So in order for it to be waived, somebody would have to ask for relief from that requirement, and, because the city, well, it says waived by the board or the building inspector. So the building inspector, under some circumstances, could waive it, but I can't imagine what they might be. The survey, if you're dealing with a 100-acre parcel, which we don't have here.
Is that the town?
Yeah, exactly. So surveys can be very expensive, particularly on these larger tracts of land. And these rules are probably all emanating from, the same place. So it can cost tens of thousands of dollars to have a survey done in certain circumstances. And that might justify relief if we didn't really need to see the survey in order to evaluate the request. So I think it's fine to have that in there, and I can't imagine the inspector would waive that requirement unless he was on very firm ground that it was unnecessary.
Well, I mean, I can think of one like the guy with the leaky roof, that you don't really need a survey for something like that. Not leaky roof, but
I know what you mean.
You know which one I mean.
Yeah, oh, yeah.
Cookman or Kent or one of
Yeah.
those streets, yeah.
Yep.
Failed porch.
And some people have them handy because they just bought, and others are confronted with this big expense. Did we skip anything that you wanted to talk about?
nope.
13,
Oh, I have a question, oh.
Go ahead.
So, no, mine's 14,
okay.
so go ahead.
Do we need 13.3? Because why are we singling out the media since we tell everybody they need to behave?
And they don't come, they just watch it on television.
And second, I'm not quite sure what the last sentence in 13.4 is. It almost sounds like we have a sergeant at arms or something, but it also seems repetitive to everything else that's in there.
So, as to 13.3, this is almost imposing a duty on the chair or the board members to require orderly conduct of someone else, because these are our rules.
Yeah, but 13.4 does that. The point 3 is repetitive, in my view, with both 13, certainly first sentence of 13.4. We say everybody needs to conduct themselves in a orderly manner and follow the direction of the presiding officer. I don't know why we need to tell the media that separately from anybody
I
else.
wonder if there was an incident
Well, there
at
may
one
have
point.
been.
There might have been.
When
'Cause it's so
Jerry,
weird
when he
that
would
it
bring out the gavel, you're in for a really good meeting,
So I completely agree with that.
That's
I don't
crazy.
see any need to
To single them out.
to
and then-
say you especially need to behave.
And then I'm not sure what the last sentence in 13.4 is referring to. Persons designated by the presiding officer shall be responsible for ensuring that reasonable and appropriate dress standards are observed at the meetings. We don't have a sergeant at arms. We say in 13.1, you have to observe dress and conduct. That's 13.1. And I don't see why we need this, what that last sentence is doing.
Dan, are you following that at all?
No, she's left us.
I know, that's what I'm saying. So this is probably a holdover from some time ago, saying that the presiding officer may charge somebody else here, city employee presumably, to enforce proper dress code standards. I mean, we don't have, you don't send any, yeah. And you don't police, you don't police dress codes.
And standards of conduct.
Suit and tie.
We don't enforce it in the restaurant, so why should we
Yeah.
enforce
Right.
it here?
No, the dog is sitting there at their seat.
Reasonable and appropriate, too, begs a lot of questions,
No,
so.
but
Very
the things that,
subjective.
13.1 says
Right.
there's a dress standard in code of conduct.
Mm-hmm.
The presiding officer enforces all the rules, and I don't think we need to, I have no idea what this last sentence is doing, but it sort of bothers me because it seems like,
Yep.
at a minimum, overkill.
Yep.
So-
So 13.3, we're gonna
Delete.
delete, and the last sentence of 13.4, we're gonna strike.
And 13.4 becomes 13.3.
Yes.
Right. Appeals and applications. We actually did ask the city to modify their application by requiring photographs, right? And that was
Yes, we
done?
did.
Strongly encouraging or
Yes.
something, yeah.
Thank you,
Some-
thank you.
yeah.
Yep. Mhm.
I have a question on 14.6.
Mm-hmm.
Is it 10 days in advance? Are they business days or 10 days?
Well, this says 10 days.
I know,
so
that's
I'd-
what I'm asking.
I'd say it's calendar days.
Okay,
Yeah, but that, almost, I checked, everything that was less than
7?
7 had calendar to make it clear whether it was calendar or business. Everything else, it just says days. So I
okay.
wouldn't start adding calendar unless we're going to be consistent through the whole thing, 'cause otherwise somebody's going to say, here it says calendar, here it says.
Okay, well, that was my question.
days.
So Ann, do you do it by 10 business days or 10 calendar days? All the documents have to be submitted within 10 days? So you, no, but you count Saturday, Sunday? Okay, that's what I just wanted to check and see. I didn't know the answer to that question. No, I know. Okay. No,
So-
just checking because I didn't know the
So
answer.
typically, you wouldn't, and I've seen this before, people writing something or inexperienced people will say, I'm going to give you 30 business days, which is impossible to
Right,
calculate.
right.
So if you've got a period of like 5 days, or even 7 days to act, and there's a holiday and a weekend, it might be appropriate to say business days to give somebody a fair notice period or whatever it is. In this case, I think 10 days definitely means calendar days. and-
Okay.
Yep.
And then the next one on 14.8, it says the limitation shall not apply if the board finds a material change in facts. But a question is, it says above it, like, the board had rendered a decision on the same or very similar application. So somebody who comes in with a similar application, but it's not the same, you could, not reconsider them? Or do you mean that it has to be the same applicant?
So this makes perfect sense if you're talking about an appeal as opposed to an application, right? So we've decided that the appropriate interpretation of the code is X, and somebody comes back in 3 weeks later and challenges the same thing. Well, we have the right under this rule to reject.
And this is an appeal of the building inspector's decision?
Okay. So I would interpret this with respect to an application for a variance to apply to the individual and not to other individuals. So if you say somebody can't have a feature, an exterior feature on their house, like a portico or something like that, you couldn't say because we denied theirs, you can't apply for one if you're a different individual, because one of the things we keep stressing is that these cases, even though they might be very similar to one another, are to be considered independently, and whether you've got an exceptional practical difficulty or not is not something that we would determine for this individual and then apply it to that individual. Those are case-specific. This is also a rule. It would be best if it was in an ordinance, saying you can't bring you as an individual can't bring a substantially similar application within 18 months or something, that would be a stronger authority than just merely our rules. I don't think state code speaks to that. So our rules are not as, strong a tool as an ordinance would be or as state law would be. Are we good on that? What's next?
The only other thing I have on this page, or maybe at all, is 16.1, after 10, I think there should be the word days. No later than 10 after the filing, it says now.
Yep.
So it should be 10 days. And with Bill's thought, again, I had the question, do we write calendar or, we're not going to just leave it 10 days. That was a good thought you had, Bill.
So seeing a number of these typos, I'm going to say that many of them probably occurred when I didn't have an editable version to work from. I got it typed by somebody who typed it up for me. So I think some of these, like that example there, is just a failure of the typing.
Sure.
The 16.1 that's a motion for a rehearing of one of our decisions, right?
Yes.
Okay, and I just want to make sure that, playing lawyer for a few minutes, it's not later than 10 days after what?
The filing of a decision.
So
What is a filing of a decision?
no, that's a good question. So the filing of the decision is the issuance of the notice of decision.
Then why don't we say that?
Pardon me?
Then why don't we say that?
Okay.
What we did today
Yeah.
would start the
Yeah, because
appeal clock.
that's basically a jurisdictional
Very good point.
decision, and I think to be fair to people, they need to know when it starts.
Okay, now I lost my place. Where is that?
It's
That's
16.1.
16.1.
16.1, the
Got
first
it.
one.
Yep.
10 days after the issuance of, what did we say?
So,
The notice of
so
decision.
the state law says something like the appeal period runs from I think it does, it might say the filing of the decision. So what I might want to do is retain that language and add as
As reflected in the notice of decision?
Decision, yeah.
So we get your, so
Whatever,
we get your point.
That's fine. I
Yep.
just wanted,
Right.
because people need to know when the period runs.
Right. Yep. Sometimes a notice of decision might say, case heard or decision rendered in December, written decision issued subsequently, and then below that, decision filed on. We don't really, march down with the decision and file it and then start the clock, but I think that is the language in the code. Okay, so we're going to address it, though, and make it more
Okay.
clear. Yep. Anything else?
I did not have anything else.
I have one thing. It's not on this, but it was, I don't know where you add suggestions, but something that I've thought of is that in some cases, something might come to us and it has state requirements that it has to meet, federal requirements that it has to meet, or city requirements that it has to meet. Should they and this is a question I'm asking you, should they be completed before coming to the Board of Adjustment? And I'm looking back, at what you were talking
We
about.
had the case on Hickman Street for the fire escape, and the board felt, I know you may
No,
have
I
been,
was
we
on,
were
it was my
very-
very first meeting.
We were very afraid of approving something that violated the fire
The fire
marshal.
code.
And we're like,
Yeah. And they hadn't gone, do you remember, Fred, that case?
Was it an
Beach
appeal?
Park Hickman.
They had already gotten, I guess before I was on the Board of Adjustment, to be able to change their back stairs. It's a condo, 6 or 8 units or something. And they had these rickety back stairs, and they had gotten approval to change them. But the city turned them down correct me, Mary,
no, you keep
because,
going.
because,
Fire.
because of the fire code, they needed to have fire doors and something with the windows and, you know, stuff to, so that if children were up on the third floor, nobody died, you know? And they didn't want to do that.
Well, they wanted to replace their stairs without
But they didn't want-
spending $20,000
Correct.
on sprinkler
Right,
systems.
right.
The fire marshal one.
And
What the
fi-
fire
and-
marshal wanted. But there were also, it wasn't just the sprinkler systems, it was just fire doors leading out, you know, and I mean, it's a rental unit. There are 8 rental units. They're making a lot of money. Anyway, and they didn't want to spend the money to meet the code.
I don't know what they ever ended up doing, because
Well, sometimes I walk down,
To see.
no, I don't walk there, but I walk down King Charles and you can see the rickety stairs are still there.
do anything.
But that's what I wonder, if before they come to us, if there are federal requirements or state requirements or even city requirements, can you give somebody a variance to do something when there's things that they have to do and they haven't done yet?
It also came up in the Bellhaven, right?
Yeah,
The-
because you all,
The fire hall, the aisle between the buildings, the fire expert said that's too narrow for us to get equipment down there. And
So I think it's up to the city to tell us what the posture is for the applicant at any given time. So we oftentimes hear that if you grant this variance, then this allows the applicant to then go through another process, ultimately in an effort to get a building permit. The process might take them to the planning commission, or it might just take them straight into the office. But if what they're proposing to do is not compliant with other layers of the code that we're not authorized to modify or haven't even been asked to modify, then that's their problem. I mean, we can't, I'm not sure how we would write that rule, because if somebody doesn't tell us what this obstacle is, we're not going to know that it exists. We're not building
well, we
code
knew
people.
because the city said they didn't meet the fire code. That was in the building inspector's report. That's how we knew, otherwise we wouldn't have known.
this goes down to a question I have for city code, this thick, is extremely thick. We spend 99% of our time in section 270. If you search for the word variance, it pops up in other places. One example is section 159, which is flood zones. Flood reduction. And when the Bellhaven first came to the Board of Adjustments, and they were looking for a variance to build in what was a extreme flood zone, Jerry stopped them cold and said, we go there, I have to open up this section of the code, section 159, which has 11 points of, criteria. So I guess my question
Well,
is,
that's not exactly, that's close to what
close,
happened.
okay.
So they came in and they, as part of their case, they wanted us to know that. As part of their case, they wanted us to know that they intended to build underground parking because it was a component of their case. It was what it was, the cost of it was a justification for
Right.
asking for. But the variance had nothing to do with the flood zone. They only asked for one variance, and that was from the gross floor area.
Correct.
So it was pointed out by Jerry, but it could have been pointed out earlier by staff that, hey, you can't even have underground parking on that site.
Jerry was warning the city, saying, look, you're going to put your FEMA insurance at risk.
Right. So,
okay.
so if the applicant comes into us and says, this is what we plan to do, we have the absolute right to say, the law forbids you from doing that, therefore we're not going to take that into consideration. So we're going to disregard a huge element of your case.
Okay.
And of course, they don't want to go forward under those circumstances.
So if we were to get a variance request, the building inspector, if it was against anything in the flood zone, it would clearly say in the building inspector report, seeking, in the agenda, seeking a variance on 159-XXX. We would see it, we would know, which would then take us into a whole different path.
So what should happen, and some of these cases are complex, so you can understand it, why it doesn't happen in every case.
Right.
But what should happen is that the applicant meets with the city and they come to an agreement as to what variances are needed in order for them to do what they want to do. I guess it's possible that they don't know exactly what they want to do, and they still want, they could have said, we want this variance from the gross floor area, and we'll wait until later to decide whether we're going to do underground parking because it's unclear
Got it.
whether we could do it. And then we would have heard their case. Now, they would have probably felt like they were not in a position to make as strong a case as they would like, so they waited.
So we only rule on the variance that is requested, bring nothing else into. I guess the final question then is, we spend 99% in 270. It's a rare chance. I've never seen it, 159. Is there anything else in city code that would, I mean, is it just a moot point? I don't think would ever come to
So
us.
I would take a pretty strict view, but Max Walton is involved in a case right now in Kent County where the question is whether the applicant has submitted all the necessary information for their application in order to have the vested rights to move forward before the enactment of an ordinance which would prohibit what they want to do. So we hear requests for variances, but we also hear appeals from interpretations of, I think it should be the zoning code. But there's a subdivision code out there too. There's a code that relates to site development, all kinds of things. And I think there's an argument that can be made that we have the jurisdiction to hear an appeal from a decision that an application was not duly submitted if that became
Okay.
but I would not want to open the door to hearing appeals from anything other than zoning code interpretations, because there are people who feel that they're aggrieved by the city in all kinds of different areas.
Yeah, we don't,
And,
all right, so we
we
don't go there.
shouldn't be the arbiter
Agree.
of that, right?
Good.
I have another question then. On when you were saying that, you know, the house on State Road, kind of just at the big white house.
You're too far from the
I'm
mic.
sorry, the big white house on State Road. So in the course of the hearing on that, we discovered, and I don't know who asked the question, it might have been me or not, that they actually, that once we gave them a variance from the setbacks, they could use that variance in any way they wanted. And they could build a pool, and they did not have to obey the normal setbacks for a pool. And that came up in the hearing. And Matt said, no, if once you give them a variance, they got a variance. And they don't, from the side yard and the backyard or whatever, I can't remember what they all were. But the pool stunned me because the pool has their own set of setbacks and fencing and all the stuff they're required to have. And so what you were saying, that once they get the variance, they got it. And they could,
Well, it depends on,
remember that one?
so it depends on the actual motion that's made. So let's say, for example, that somebody has already in error. It could be fairly innocent, or it could be sinister, that they have installed a pool and they seek and obtain a variance for that pool. If the pool's already there, then it is very likely that the variance is going to be to grant only the relief necessary to allow that pool to be legal, if in fact that's what the board were to do. But if this board were to say there's a 15 or a 20-foot setback off of State Road and we're going to modify it to 8 feet, well, now there's an 8-foot setback, so you've expanded the building envelope, which enables them to do whatever they wish to do within their building envelope. You've changed the law as it applies to that. So we have a duty to be mindful of what is the minimum variance necessary to relieve the asserted difficulty. And that should be something that you keep in mind when you're debating these.
Right, because they didn't ask for a lot of variance, if I recollect. There weren't a lot of variance they asked for. I can't remember exactly. It was an
Odd-shaped lot, yeah.
which they
And it had two front
Yeah.
yards, and they thought they had a side yard and a front yard.
Yeah.
And they actually had two front yards, I think, which,
was a corner lot. It's that big, ugly.
Yeah, I know what
house.
it is. I
You
know
know,
the house.
Everybody, I hear about it all the time.
yep, so that's just instructive of being careful. Certainly, you wouldn't say, we're going to give you a variance and reduce your setback from 15 feet to 8 feet, but you can't put a pool in there.
You can't say that?
Well, what,
If you live next door to a pool, you,
so I don't know, there might be an there might, I
You
mean,
know, you do the opposite and say, for use as a yard. In other words, put a positive and say not what you can't use it for, but what you can use it for. Play yard, side yard, whatever you want to call it.
we'd have to be very careful of that. I mean, these rules stay with the property forever, once we grant them, unless the property's redeveloped. So I don't know. I think it's something that, in the context of these rules, it's important for us to keep in mind that there are potential consequences.
Sounds like there are bridges to be crossed when we come to them.
Yep.
Okay. We all done with the rules of procedure?
Okay,
was great.
are we voting on the rule, or are you going to bring back the final version?
So what is your pleasure in that regard? I mean, I have a sense, what we could do is, I could make the changes that I believe you're about to vote on if you do, and then between Edie and I, we could finalize them, and then you could sign them when you come back after, voting their approval. Or, do we have a meeting next month? But do we have a meeting?
I don't have anything at this point.
Okay,
Okay.
so when will you know whether we're gonna have a meeting in February?
30 days out from February, whatever.
Well, that's today.
That's now, yeah.
that's today, it's 30 days out.
Right, so we, well, so that is also is a factor. So if we want to get these rules done, we can vote to make the changes that were consented to, and then between Edie and I, will get them in final form.
Share 'em out.
And then,
So you want to vote to accept the minutes with, I mean, the rules with changes?
that we
Okay.
discussed, yep.
All right. I move that we accept the rules for the Board of Adjustment with the changes as discussed
Seconded.
today.
All in favor?
Aye.
Aye.
Thank you. Good
All right.
work, good work. Other business, I am unavailable. It looks like we will not have a meeting in February. I am not available in March. If I'm out, Jan will be acting chair. Motion to adjourn, if there's nothing else?
I move to adjourn. Move
Second.
to adjourn.
All in favor?
Aye.
Aye.
This was a great discussion, thank you.
I think this was, it just kind of serendipitous worked out.
It was great.
And it's and to let us all interact a little bit